Okay, so now let's look at some case law that has been decided under a number of these statutes. And first we're going to look at the Conlon case, which was decided just this year under the Cyberstalking statute. So factually, you'll see defendant and the victim had dated as teenagers but had no further contact as adults. At some point, the victim, and it's not clear in the opinion how or why, is on a national news program, and the defendant sees them and rekindles something or other in the defendant. And so the defendant tries to restart this romantic relationship. The victim makes clear that she doesn't want anything to do with this, and that triggers then the defendant engaging in this cyber harassment campaign. And you can see in the opinion the various kinds of messages and things that the defendant does. The court describes it as an escalating campaign involving email, text, social media, telephone, face-to-face, including the victim, her family, her work colleagues, her church members, and various other people. So there are two issues in the case. The first issue was the evidence sufficient to show the intent to kill, injure, harass, or intimidate? And the court answers yes, and I think this was a relatively easy one, but the point is what kind of evidence do you need to prove that intent? And you can use circumstantial evidence, and the circumstantial evidence can include simply what the court describes as the increasingly ominous tone and content of the activity. And I think it's pretty typical if you look at some of these cases, this pattern that it starts out maybe even innocuously, and then it steps up to something that's kind of mildly disturbing, and then it becomes something really intense. And the court says that kind of stepping up can provide the circumstantial evidence of the intent to, in fact, cause some kind of harm, harass, intimidate, or even physical harm. Issue two is this question of constitutionality. And so the defendant argues that the statute is unconstitutionally vague, because after all, what does harass mean? What does intimidate mean? And the court says no, it is not unconstitutionally vague. Harass and intimidate, the court says, are readily understandable common terms. The statute doesn't have to specifically define what those mean. They're not obscure at all. And then, I think very interestingly, kind of from the legal perspective, the statute doesn't criminalize otherwise lawful speech. And if you look at I gave you a redacted version of the opinion. If you look at the original opinion, it talks about some other case law involving statutes that were trying to criminalize wearing the regalia of the Ku Klux Klan, so wearing the white hood and that kind of thing, simply wearing that. And in those cases, there's case law saying you can't criminalize just that, because it could be lawful to wear that. You might wear that costume in a play. You might wear it to make some other kind of point. You might wear it as a Halloween costume. It would be kind of a horrible thing to do, but somebody might. And though that may be in bad taste, it shouldn't necessarily be illegal because it's free speech. But here, the court says, because there's both intent and effect, you have to have the intent and also cause the fear, that does trigger liability. So the next case that we want to look at is the Infante case. So the Infante case, the defendant meets with the victim on an overseas study trip, a kind of college trip, tries to connect with her on Facebook, sends her emails, leaves her phone messages, leaves her flowers, and even goes so far as to visit the campus in Rochester where the victim is going to school and going to her classes and trying to find her. So the defendant's story, of course, is, well, I'm in love with this person. I'm infatuated with this person. I think we're destined to be together, and she just doesn't realize it yet, and I've got to convince her. And you can sort of see in the defendant's mind there's some kind of romantic comedy playing out, and in the victim's mind there's sort of a horror movie playing out. So the issue that arises under 2261A, and this is actually under Part 1 of the statute because he's actually traveling, and it's also a prior version of the statute, but the issue is still, is there an intent to harass? And so here the court says and talks about, can the intent to harass be inferred from what actually happened, or must you have to prove the subjective intent to harass? And this court says you in fact have to prove that subjective intent. It's not something that can just be inferred, would a reasonable person think there's an intent to harass, but you have to show that in fact the defendant had the subjective intent to harass. Now, that's not inconsistent with saying you can use circumstantial evidence. You can still use circumstantial evidence to prove the subjective intent, but it's not would a reasonable person conclude that there was this intent, but in fact does the evidence show that the defendant had this intent. And here the court says, no, there was not enough evidence to show that subjective intent to harass. He gave some statements to the FBI, and those did not show an intent to harass, and the court here said that, in fact, really all it was this kind of misguided romantic hope that he could renew the relationship. Now, I think when you put these two cases together, the Conlon case and the Infante case, it's very interesting to see that contrast. Now, if you read the Conlon case, you can see the conduct there. He was sending pornographic, sexually explicit pictures. He was engaging her church members even after she told him to stop multiple times. And the conduct seems to be more ominous, perhaps, than the conduct in the Infante case. But on the other hand, if from the perspective of the person who has to endure some of this, the conduct of Infante could be pretty frightening. And so where do you draw those lines? Where do you draw the line between something that is socially inappropriate, perhaps, and perhaps disturbing, but on the other hand, something that is should be unlawful and considered a crime? And I think we all can see that there are places at which we can make those judgments probably readily, easily. There are places at which it can be fuzzy and maybe difficult to make those judgments, certainly in the context of a criminal statute. So the next case we'll look at is the Jordan case. So, this case, I think, illustrates, again, the kind of conduct and the kind of escalation that can happen. So and this is often, unfortunately, the kind of thing that you see in these cases. There is initially a legitimate, so to speak, relationship. There's a dating relationship, maybe even there's a marriage relationship, and then at some point that relationship falls apart. And it's not uncommon, I think, at least from what I've seen in these kinds of cases, that there is someone, unfortunately, with an abusive personality, and that abuse could be physical abuse, and then it could be physical abuse that spills over into the virtual world. So here, the abuse is bad enough that Thenalt, the victim, kind of tries to get out of the state. Jordan continually calls her. And then he does something that's, again, characteristic of a lot of these kinds of cases. He starts posting false information about Thenalt. He, posts an ad for prostitution services on Craigslist, and she gets calls on that ad, and does all these kinds of things. And this is a classic sort of pattern. He registers a domain name and writes about some of this stuff. He even tries to contact the British embassy when the victim's aunt is over in England. Continues to send fake documents, fabricated things all around the world. And so you can see this kind of pattern of escalating conduct. And so again, the issue is there sufficient evidence to show that there's a subjective intent to harass? And I think in this case, it's relatively easy for the court to say that, yes, in fact, there was abundant evidence, and it showed pretty clearly that his conduct was calculated, was elaborate, and even if he denies that subjective intent, the circumstantial evidence shows that that intent existed. So our next case is the Reus case, and again, I think the case gives you a kind of typical factual scenario. they meet. Their relationship becomes romantic. It's at a distance online. Fisher tells Rose that she is a widow. They plan to meet, but then Fisher changes her mind. Rose decides, I'm going to go meet Fisher anyway, and finds out, lo and behold, Fisher is married. So Rose begins then harassing, sending threatening and vulgar emails, and I think the thing that's really frightening about this case is posts pictures of Fisher's children to websites that are used to solicit sexual activity. Remember last week I mentioned there are a variety of sites that involve things like parents pimping their children and other horrible things like that. So you can see, again, how this conduct escalates. The specific legal issue in the case is whether this conduct warrants sentencing enhancements under the federal sentencing guidelines. Don't worry about the details of the sentencing guidelines. Just see that in this case, the court says, yes, this conduct is severe enough. And I think it's really the posting of the photos of the children that warrants sentencing enhancements. Our next case is this Vonaida case. So this case is interesting because of its factual context, and I think actually this case is difficult because of its factual context. So if you remember the Virginia Tech shooting, one of the large, terrible campus shootings in the United States, so this guy Vonaida, who's a student at Penn State, posts some statements on his MySpace account. I guess MySpace was sort of still a thing when he did this, but he's lauding the Virginia Tech shootings and the Virginia Tech shooter. He's venting some misplaced rage or whatever it is. And the issue is here, under 875C, the threat statute, does this constitute a threat that can be prosecuted? And if it does constitute a threat, were these threats transmitted? Or was this more like, is the MySpace page more like a kind of diary entry where, again, the person might be disturbed or might have some issues or might just be working out some anger or whatever he's doing, but it wouldn't necessarily be a crime. And here the court said no, a reasonable jury could find that this reflects a serious intent to inflict bodily harm. The threat doesn't have to be imminent. It can be something that may occur in the future. And the court said postings on MySpace are necessarily transmitted in interstate commerce. So at least for the purpose of the indictment surviving, the court said this survives. So I think this case is a little bit difficult. I mean, we do have to be really sensitive, obviously, about these kinds of terrorist activities or just a crazy person or a student. We know how difficult all these issues are. But the question is, how do we intervene in those circumstances? Is it the law? Is it the criminal law that intervenes? Is it other kinds of social services? Is it a mixture of two? How do we do that? And how do you write a statute, and how do courts interpret statutes that do that? These are difficult questions. And our next case is the Alka Baz case. So this case, I think there's a number of cases in this set that are disturbing. This case to me is one of the most disturbing cases in this whole set of harassment cases. So here, this guy Alka Baz, his actual name seems to be Baker, is trading messages over the internet with this guy Gonda, and they just know each other from these chat groups that they're both on. And what they're on is groups in which people write stories depicting really hideous, violent acts, including rape, torture, and murder of young girls. So they're trading stories. They're trading kind of novelistic stories. But you see in the opinion how there's this kind of back and forth about, we need to really meet up and actually do this. And of course the defense is going to be, well, that was all kind of role play. It was all part of the being in the role of this author. We didn't really want to do anything. And so part of the issue, are these really true threats? And the court goes into some detail about what the mens rea and actus rea requirements are. So what is the mental state and what is the action that is required to violate this? So this court says the mens rea requirement is proof that a reasonable person would have taken these threats as a serious expression to inflict bodily harm. And there is a note in the case that some courts, a minority of courts, require a specific intent to harm a particular person. So clearly here, Alka Baz's stories and his statements were kind of generalized. We want to do this to somebody. It wasn't, there's Mary Jane, let's go get her. So some courts say it has to be, there's Mary Jane, let's go get her. Other courts, including this one, is any proof that a reasonable person would take this as some kind of serious expression of intent to hurt somebody, some real person, but not an identifiable person necessarily. So what is the actus reus? What's the that's the mental state. What is the action that is required? So this court kind of goes through some precedent on this, and the basic standard is, well, do you communicate this threat generally? Do you have to communicate it to some specific individual, or can you communicate it to someone with some connection to this specific individual? And this court says the kind of some connection standard is too vague, and what a threat actually is an effort to achieve some kind of goal. And even if it's innocuous, even if it's a prank, it still could be a threat, but it has to have some action that involves a threatened individual and an act to act on that. So this court says the standard is whether a reasonable person would take it as a statement of serious expression of an intent to inflict bodily harm, the mens rea, and then would perceive the expression as being communicated to effect some change or achieve some goal, a specific goal, through the intimidation, the actus reus. So it's not just kind of sitting out there in the ether, but there's a goal behind it. The court notes that the purpose of the threat statute isn't so much to regulate speech, which would raise constitutional issues, but is to protect the recipient of the threat, and particularly to protect the sense of well-being of the recipient of the threat. So we say that everyone has a right to free speech, but if your speech is threatening and is seriously impinging on someone else's well-being, you're impinging in a sense on their liberty, and so we find a space in there in which we can, the law can step in and regulate that conduct. And the court says if the communication is not transmitted, then it can't be a threat. And here the court said these communications between Baker and Gonda, as disturbing as they are, can't be threats because they're only communicated between the two of them. They're not communicated to any potential actual target, whether it's a recognized individual or just kind of generally to the public. They weren't made public. They were, according to the majority opinion, private communications. Now there is a dissent in the case, and the dissent has a lengthy section. If you're really interested in this and you can stomach it, you can get the case off of Westlaw and read the lengthy quote from one of Baker's stories. I've put it in enough detail in the redacted version so you get a sense of what's going on. I left a lot of it out because it really is disgusting and horrifying. So the stories were not just kind of general. I mean, they were really explicit, horrifying stories. So the dissent says, look, if you look at these actual stories, and you look at what the statute actually criminalizes, and the dissent says, really what the statute is doing is setting up an objective standard that a reasonable person would perceive a threat. In that case, the indictment should not have been dismissed. So I think the two opinions in this case leave us with a tension that we mentioned at the beginning of this section on cyberstalking, which is that there are cases in which there's a pretty clear communication to an identifiable person, and it escalates, and you can say, yes, that falls in a category in which the law should step in. There are cases in which it doesn't go that far, it doesn't escalate, it's relatively innocuous, it's just somebody's hitting on someone at a club, they're a little persistent, eventually they go away. It's maybe annoying, but the law shouldn't step in. There are cases in between where there's a fuzzy area. And then there are also cases in which there's some speech that we find really, that most of us find really disgusting, but that maybe the law can't criminalize, or maybe the law can criminalize. And the question is, where and when and how can the law step in? So that's the end of the lecture for this week. We'll talk about this a bit more in class on Thursday, and then we'll pick it up again in our lecture for next week.